I am going to be talking about Sam Bankman-Fried's appeal process and Rule 33 motion. So if you have any questions or things that you're curious about, feel free to drop a little message. Also, if somebody feels like it, you can make sure that you can actually hear me. I'm still kind of figuring this out. So a little help is always good. Oh, and here's Steve. Wow. Thanks, everybody, for joining. Just as more people come in, I'm just waiting a couple more minutes for our official start time. In the meantime, you can browse my bookshelves behind me. Real flex. Or we can just get the numbers up. Here's cat video time. He's not happy, but he's purring. This is just cheap exploitation now. All right, we will get started very briefly here. I'm just giving a couple more minutes for folks to come in. I've already said a couple times, more people keep joining, but this is going to be a discussion of Sam Bankman-Fried's kind of various appeals and related processes. It's been a couple weeks. I talked about it a bit. I don't pay. Frankly, I wrote a book about the guy, and so I have eased off a little bit on how much attention I pay. But about 2 weeks ago, on April 28th, there was a big development. His Rule 33 filing was over. Thank you. I do look like my cat. It happens. It happens to all of us. The April 28th, his Rule 33 motion was dismissed by Judge Kaplan, and so his routes to not serving his prison sentence are very close to zero now, and we'll get into the details real shortly here. In fact, well, I should have grabbed something to drink. We'll make do. For those who, I think everybody who's tuning in knows, I'm going to start slowly here. I'm David Z. Morris. I'm a former reporter for Fortune and CoinDesk, and temporarily doing my own thing before starting a new job soon, which a little tease for those lucky enough to be tuned in. I wrote a book called Stealing the Future, which, in fact, I will plug here by showing it all. This is what it looks like. This is a deep dive into Sam Bankman-Fried's fraud and his crimes and his trial. And one of the things that I find most fascinating, kind of the thing that really motivated me to write this book, is that there is a pretty significant number of people who are in the business of trying to argue that Sam Bankman-Fried did nothing wrong, that he and that has now been sort of formalized in his appeals process and in what's known as a Rule 33 filing. The appeal, let's just sort of go through this bit by bit. The story that they're trying to tell in Sam Bankman-Fried's appeal is essentially the same story that Sam tried to tell before the trial in a bunch of interviews in December of 2022, right after the exchange collapsed. And then, frankly, all the way through the trial. They had really one version of events that they thought was going to sort of get Sam out of responsibility. And just so everybody knows, this is live, so I am actually talking extemporaneously here, and I will stumble a bit. The story that they tell in a few different versions, but it really boils down to the same story. The argument is that all of the money, and for those of you who don't remember the kind of crime, Sam Bankman-Fried ran an exchange called FTX. He also owned a hedge fund, essentially, called Alameda Research, which actively traded and tried to profit from trading cryptocurrencies. Sam Bankman-Fried took roughly $11 billion worth of money from depositors and also lenders to FTX, and then handed that money to Alameda Research to trade with. And basically, they lost all the money. They also spent a bunch of the money on illiquid venture capital investments, on speculated speculative cryptocurrency tokens, and then some fun stuff like a big house for Sam Bankman-Fried's parents. And the parents' role in all of this is going to be really important as I get into this discussion of the appeals process. Currently, Sam actually doesn't have a lawyer. He's representing himself. And his mother, Barbara Fried, has had a really large role in his various sort of appeals and continued filings. So the story that the defenders of Sam Bankman-Fried tell about what they claim happened is that they claim all of that money that was given to Alameda Research was legitimately borrowed through what's known as a margin lending program. And for those who don't know, it's not that important, but margin lending is basically where you borrow money to bet that, for example, Bitcoin is going to go up. On margin means you're borrowing money. And if you sign up for that program, it's true that on FTX and in a lot of other venues, you do sort of give people the right to borrow your assets. So you're signing up for a two-sided deal. The defenders of Sam Bankman-Fried have always argued, and Sam Bankman-Fried himself argued, that using all kinds of slippery language and deceptive framings, that all of the money that was loaned to Alameda Research was borrowed legitimately through this margin lending program. Now, at trial, this was completely and definitively disproved because FTX was not only a margin lending platform, it also offered spot trading, which is you're just exposed to the live price of an asset. You're not borrowing any money. You just buy an asset, hold it, and hope it goes up. That's spot. Spot customers did not agree to have any of their assets loaned. And in fact, there was a significantly detailed clause of their version of the user agreement, which made it very explicit that user assets were not property of FTX or FTX Trading Limited, and that they really had no rights to be doing any of the investing or speculating with it that they later did. This is really open and shut. The percentages, frankly, I've forgotten at this point, but it was a very small percentage of the balances on FTX, or relatively small. I think it was roughly 10 to 20% of the balances on FTX were actually in the margin lending program. That means that if Alameda borrowed all of the money, it means about 80% of that was not in the margin lending program and therefore not eligible by any reasonable definition for being borrowed by that Alameda as a customer, which the question of whether they're a customer is a big part too. Now, to get into sort of the more material stuff, obviously Bankman-Fried has this, well, not obviously, but those of you who have been following the story, he's extremely passionately deluded that he is innocent and has really maintained that in the face of observable fact for going on 3 years now. In November of last year, he had his first appeal hearing before the Second Circuit Court of Appeals. And he had a famous appeals lawyer, Andrea something, I'm forgetting her full name right now. And this person, again, argued that because all of this money was legitimately borrowed, according to their version of events, and then put into all these speculative investments, so venture capital investments into whether companies like Anthropic or tokens that went up and down. Everybody has maintained that FTX was solvent and actually had the money. Now, this is not how a crypto exchange works, right? You don't take somebody's deposits, then go buy some other asset, and then when they ask for their money back, you swap it back to the asset, right? So at the end of FTX's bankruptcy, they had something like 2 or 3 Bitcoin actually in their possession, but they owed customers something like 300 Bitcoin. So they had taken those Bitcoin assets that people either thought they were buying or had actually deposited on FTX. And instead of having the Bitcoin for people, they had used that money, whether the cash or the Bitcoin that they went and then got rid of, they used it to do other things with. This was the crime. This was the fraud. But Sam's appeals lawyers, and then in subsequent filings, they have consistently argued that, no, this was totally fine. We had all of the money the entire time, even though, yeah, sure, we went and did something else with it than what we promised you. We had the money, therefore there's no crime. This is a nonsensical argument that they have repeated again and again, and it's really wild to watch them go for it. So that was the appeals hearing. That was in November. It did not go well. The appeals lawyer basically got laughed at. I mean, not basically, literally got laughed at multiple times by the judges who were very dismissive of her presentation of these arguments. Now, fast forward a bit. in early February. And by early February of this year, it appears Sam Bankman-Fried no longer has any legal representation. He doesn't. I believe he does not have any money left from his crimes. I don't think he, hid some stash somewhere. He even the remains of the money that he gifted his parents, which again they are entangled in this, partly because they got a $10 million gift that was funded from FTX corporate money. Now, that gift got clawed back. That gift was being used to pay for his lawyers during the original trial. So, just to spell it out, stolen money was paying for his lawyers during the trial. Whatever was left over appears to have been returned from that money that was given to his parents. So his parents don't have any money. He doesn't have any money. He's now representing himself. It also is possible that he has money and he just can't find a lawyer who's willing to file this bullshit. But that's, it's speculative. So the Rule 33 motion, which he filed originally in, I believe, March, he was working on it in February, filed it in March. Rule 33 is when you have been through a trial, you've been convicted, and then there is new evidence discovered that you or your lawyers believe is exculpatory, that you believe releases you from, that would prove you innocent, basically. Sam Bankman-Fried filed in March this Rule 33 motion, and it is quite wild. The three people who he claims are going to offer new testimony that will exculpate him are Nishad Singh, you'll remember that name, Ryan Salome, a name you also might remember, and I'll go through all of them, and then Dan Chapsky, who you might not know his name, but he was an FTX staffer. To sort of go in order of how ridiculous these claims are, I guess. Ryan Salome has publicly said, and in each case, Sam argued that these people were kind of bullied or pressured. He used these in the motion, he used the word silenced to describe why these people didn't testify. Now, Ryan Salome has actually said, and Ryan Salome was, he pled guilty and is now serving 7 years in prison because he was an accessory to part of the FTX fraud. He participated in the campaign finance fraud. He was one of the cutouts who got sort of loans that were then used to make political donations. He also specifically funneled $400,000 worth of FTX funds to his girlfriend, a woman named Michelle Bond, who ran for office in New York and who is currently under indictment for her role in that fraud. Salome has said publicly, and he's one of these like MAGA guys who basically loves to be the victim as an excuse for his own actions. And he says that he felt pressured not to testify because his lawyers warned him that he would be at greater risk. Now, Sam has interpreted this, and this is sort of true of Chapsky as well. Chapsky has said to the effect that, my lawyers warned me not to testify. Now, Sam has interpreted those statements as there's a conspiracy against me. The prosecutors are bullying my witnesses out of testifying. With Sam and with his mom as well, you can never tell exactly when they just don't understand something genuinely or when they are choosing not to understand something because understanding it would make it harder for them to maintain their like incoherent position. In this case, Sam seems to be choosing not to understand that when somebody like Dan Chapsky's lawyer warns him not to testify, a defense witness does not get immunity most of the time when they testify. So these people who are refusing to testify in Sam's defense are refusing because they might actually be putting themselves at legal risk if they implicate themselves in his crimes. Now, this is specifically relevant to Ryan Salome. Obviously, he was later pled guilty and convicted to participating in the campaign finance fraud. So he sorry for anybody who can't listen. You will get to see the recording later, so don't worry too much. So Salome actually, confessed to being involved in the crime. So it's not that surprising that he didn't want to testify because the trial was before his ultimate confession, which was in 2024. Same goes for Chapsky. Chapsky was going to testify to the effect that a bunch of what was referred to as illiquid cryptocurrency tokens and venture capital investments were worth $8.4 billion. Now, these assets were, for legal and accounting reasons, they were marked down to $0 by the bankruptcy sort of liquidators. And this is stuff like FTT, right? Like this is the token that FTX printed. They created it. And the bankruptcy proceedings, I mean, naturally they would mark that down to zero because frankly, FTT was part of this fraud. So Chapsky was meant to testify, or Sam Bankman-Fried in his filing claims that Chapsky would have testified to the fact that all of these assets were actually worth $8.4 billion instead of $0. Now, I think there's a sort of in between point that's probably more accurate, right? Like this did include things like the stake in Anthropic that did wind up being quite valuable and helped with the recovery. But it kind of becomes clear once you think about it why somebody like Dan Chapsky would not be willing to go on the stand and testify to having placed a valuation on these assets, because those valuations were then used in the fraudulent loan documents that people like Carolyn Ellison described preparing for some of these lenders, like whether it was Celsius or the what's the lender that was under a Digital Currency Group? I'm forgetting. So Chapsky was kind of an accessory, arguably, if he placed the valuations on these assets that were then used to try and get fraudulent loans. And the fraudulent loan documents were literally part of the charges against Sam Bankman-Fried for fraud. They were part of what Carolyn Ellison confessed to being guilty of falsifying. So again, Chapsky probably didn't testify because a defense witness does not get immunity most of the time, and he very much was at risk of implicating himself in the crimes. And again, Sam Bankman-Fried, delusional, thinks that this is a conspiracy against him and frames it as such in his Rule 33 hearing or Rule 33 filing in March. In April, the government comes back with its 50-page rebuttal of Sam's 10-page filing, or maybe it was more like 20 pages, the original filing. But the government comes back with a 50-page filing that just basically says everything I already said, that these witnesses were most of all already known. A Rule 33 filing is meant to be for new evidence. And, of all of these three people, of course, the most known is Nishad Singh, who was one of the confessed co-conspirators who actually testified under oath for the prosecution. Now, what Sam says in his filing is that that Nishad was pressured to lie because he was offered a cooperation deal by the prosecution. And Sam does cite some early statements by Nishad in proffer meetings to the effect that Nishad initially maybe claimed he didn't see a hole in the balance sheet, that he didn't consider it a problem. Those are actually quite intriguing if Nishad said that at first, but there are a lot of explanations for that, and some slightly more efficient explanations for that than the idea that he lied on the stand because the prosecution threatened him. A much more plausible explanation is that he lied in his initial proffer and then kind of decided to do the smart thing and actually tell the truth. Now, this is sort of beyond Sam Bankman-Fried's comprehension that somebody could actually feel bad about what they did. That's not in Sam's programming. And so for him to look at Nishad Singh and think, okay, this guy should be on my side. He should be with me, defending me. We did nothing wrong. He did nothing wrong. So obviously the only explanation is that the prosecution threatened him. And so this is just another example of, Sam doesn't really understand a lot sometimes. And so he sort of sees everything as this conspiracy against him because he has this default assumption that he's correct and innocent. Now, when things get really interesting is, Barbara Fried has been involved this whole time. And she actually filed the paperwork. She's not Sam's lawyer, but she filed the paperwork in this initial appeal. And she just kind of put her name on it. Or she didn't put her name on it. She actually filed the paperwork on behalf of Sam, not acting as his lawyer. She then, sort of in the middle of this process, while Sam was supposedly preparing his rebuttal to the government statement, Barbara Fried actually called the courthouse to ask for Sam to have an extension on the deadline. This resulted in her getting a rebuke from Judge Kaplan because she's not Sam's lawyer. She's not supposed to be engaged in procedure, for one thing. For another thing, you can't call the courthouse to try and make a procedural motion in a criminal appeal or follow-up procedure. That's just not how it works. The telephone is not an accepted means of communicating with the court. So this was very funny, and Judge Kaplan yelled at her a little bit for that. At the same time, though, she is herself blogging about sort of her big experience of this entire case. It's quite interesting. One of the pieces that I cite, and by the way, everybody who hasn't, you should go and I've written all of this up in a very long post that went out to subscribers on Wednesday. So if you're not a subscriber or if you haven't read this write up, it goes into a lot more detail. But Barbara is writing about her experience. One of the sort of pieces that I found most interesting was, and I'm peeking around my camera here to read it on my screen behind it. But Barbara had a media interview where she writes about it, and this is her quote. Um, the interview was in my office at the law school, surrounded by law books that I, of course, hoped would silently convey that I was not just Sam's mother, that I also spoke from a different, unbiased source of authority. The reporter didn't bother to feign interest as I bombarded him with what I thought were the most compelling facts that cast doubt on the allegations against Sam. And this is Barbara Fried writing, just as a reminder. When the story came out, the only reference to anything I said was his parents must be the only people on earth who still believe in his innocence. Now, what are we hearing her describe here? From her perspective, this is a journalist who should take her seriously because she's a law professor with a bunch of law books, and she should listen to what Barbara is saying. Now, of course, if you're a journalist, you're already very cautious about listening to anything being said by the mother of a convicted felon. Obviously, she is going to believe him and be sort of biased. But Barbara, and this is, I think, very typical of the broader system of thought that I examine in my book, which is this sort of Silicon Valley rationalist position that if you're smart enough, you are correct. I mean, that's basically what Barbara Fried is saying, is that because I'm a professor, because I'm a lawyer, even though I'm Sam's mom, even though I'm inherently biased, you should actually listen to what I'm saying because I'm a lawyer. I'm smart, even though I'm biased. My bias doesn't exist because I have law books behind me. I mean, I'm doing the same thing, right? I'm stealing some valor here, but it is very funny. I mean, I am actually unbiased. I have no stake in this case at all. I'm just calling balls and strikes, and the balls and strikes that everybody involved is pretty stupid. So Barbara is sitting here, sort of frustrated that this journalist doesn't take her seriously, and it's kind of a lot of that. She really is sort of a victim. She has these sort of handful of allies, like this guy, this Yale professor, Ian Ayres, who has co-authored some things with her and is a close personal friend of her and George or Joe. And Ian Ayres is out there saying, "Oh, Barbara's really, really compelling in this explanation." But ultimately, and this is the craziest part, is that over the course of a couple of posts, the only argument that Barbara Fried makes, again, is the same argument that they've been making the whole time. She quotes this clause of the user agreement for margin lending clients that says, you might get a haircut, there might be some liability for the funds that you've put on FTX. She does not discuss at all the fact that margin was only a small portion of all of the money on FTX, and that spot lenders very clearly did not agree, or spot depositors very clearly did not agree to let their assets be borrowed. She just completely ignores that reality. She focuses, just like Sam, very monomaniacally on the one narrow place where there is a hypothetical argument that this money might have been legitimately borrowed. And, for those who haven't read the book or who didn't follow the trial closely, the funniest part of all of this is that the origin of this margin lending explanation is Can Sun, the FTX chief counsel at the time. Now, on trial, Can went under oath and testified that when things were really collapsing, when all of the lenders were pulling their loans from FTX, Sam pulled him aside and asked, "What do I tell the lenders? How do I explain that all of this money is gone?" Can's son describes a hypothetical scenario that he laid out for Sam Bankman-Fried. Hypothetical that maybe the margin lending program could explain all of this missing money. If Alameda borrowed all of the money through the margin lending program, then it would be legitimate, and they just lost it, and it would be legitimate, theoretically. But Can's son at the time, while taking this walk on the beach late at night with Sam Bankman-Fried during an emergency, made clear to Sam that this was not true, that the facts actually did not support this hypothetical argument that he was laying out. So the way this went down, in my mind, and I think it's actually, the evidence supports this, Can Sun, the lawyer, makes up this false hypothetical back in, I think September or October of 2022, maybe October. I think it's October of 2022. Makes up this hypothetical. Sam immediately adopts it. This is the version of events that he gives in all of the interviews in December of 2022 after the collapse, like the discussion with Andrew Ross Sorkin, and all of these interviews where he's saying, well, we legitimately borrowed the money. I didn't accurately assess the risk, and I'm sorry for that. And I should have kept a closer eye on Alameda. That was one of the things he was saying, basically, that I fucked up. I made a mistake. I should have been watching Alameda Research more closely. But in fact, this was never true. This was never accurate. Margin lending could not possibly have explained all the money that was lost. And then Sam picks it up, and then Barbara believes him. Obviously, she, does not believe that Sam is capable of lying. One of the famous quotes from Barbara Fried is, and it's the way that she says it that makes it so wild, Sam could never speak an untruth. It's just not in him. And, that I think sums up a lot about who Barbara Fried is, which is that she is annoying, self-important, and raw. And that's a great combination. And so this thing that gets cooked up by the lawyer gets adopted by Barbara Fried through Sam, and then gets adopted by Ian Ayres through Barbara. And it never makes any sense because A, the margin lending program cannot explain this. And B, there is no rational case to be made that it's actually what the depositors expected, wanted, or were aware of, that their money was going to be invested in all of these assets. And so the claim that these assets counterbalance the obligations on the exchange and mean that FTX was solvent, which is the word that is being used. No, it doesn't, because we're talking about FTT and other fake assets that had no actual value and that did deserve to be marked down to zero. And B, solvency is not what this is about. FTX was agreeing to safely custody the assets of customers and promised not to move or trade them. So we get this is the Rule 33 motion. Remember, we had the government filing in March, and then on April 28th, we have Judge Kaplan completely rejecting the motion by Sam, basically saying that not only is this weird conspiratorial thinking where there's no actual evidence for prosecutors intimidating people, these are not newly discovered witnesses. The argument does not make any sense. Solvency is not what's at question anyway. Most of the charges against Sam had nothing to do with whether or not the exchange was solvent. It was about him misrepresenting the risk that users were facing. He was committing fraud by lying, for example, about the fact that Alameda had special exemptions on the platform. Alameda, the hedge fund that he also owned. So he's doing related party Enron bullshit while lying to people about the fact that Alameda has a normal account. Whether or not they're solvent has nothing to do with him lying there. And so all of this is just sort of him making weirdly orthogonal claims that have nothing at all to do with the actual charges against him, and having this small core of people who are just kind of repeating the same thing over and over again in slightly different ways that actually don't hang together. Now, just as in closing, as I wrap up this, half-hour video, I've been doing a good job of talking. So the thing that's interesting here is not just that, the family and friends of a convicted fraudster are lying on his behalf. I think that they're actually in genuine denial. And Barbara in particular, I think that she wouldn't be going to these lengths if in some sense she didn't actually believe that Sam is innocent. And I think that Sam, in some part of his brain, believes he's innocent too. I'm not really sure what that means, but the point being that there are kind of, two levels. And I'm a big believer in Sigmund Freud. I think that there is always two levels to the way that a person's mind is operating. I think that consciously, when he talks to himself, when he has his inner monologue, I think Sam Bankman-Fried 100% believes that he's innocent. I think that Barbara Fried 100% believes that Sam is innocent and that he did nothing wrong. These are the stories they're telling themselves when they're writing, when they're thinking in words. But I think that subconsciously, they both understand what actually happened, and they are engaged in a fierce war of denial against their own awareness of what Sam did. They are trying to repress knowledge of the crimes, and they're doing this with this public ritual, with this performance, with this repetition of an idea that doesn't make any sense, that this margin lending program explains all of the expenses. And by the way, to rewind just a little bit, Chapsky was meant to testify. Boy, my little holder here seems to keep like drifting down. I'm gonna have to work on that. So if you're getting a sideways view, I apologize. Um, so Chapsky was going to testify that all of these assets, all of these obligations of assets that were being held on the exchange that were missing, right? Like the 200 Bitcoin or whatever that were supposed to be there, but they only had 2 Bitcoin. What Chapsky is claiming is that, or was meant to testify and told Sam he would have testified to if he hadn't, been at risk of implicating himself in a crime, was that all of the assets that Alameda had possession of counterbalanced the obligations, the debts. All the assets that Alameda had counterbalanced the debts that FTX owed to its customers. Now, what's critical here is that these Alameda assets included all of the real estate investments, all of the houses that they bought for employees, cash, venture capital. These are assets that did not exist on the FTX exchange. And I'll preface this by saying I am still, I'm not really sure how exactly FTX worked in this case, but in general, in fact, almost all the time, a margin lending exchange is going to want to have your collateral on the exchange, or at least transparent in some specific way so that it can actually monitor the value in real time of all of the assets that you've put up as surety. And in a crypto exchange, often those are literally custodied by the same exchange. So you take a bunch of Ethereum, for example, say, I don't want to sell this Ethereum, but I want to use it to get like a 25% loan to go long on more Ethereum or something. But those assets are on the exchange and they watch it in real time. And if your asset value goes down, you can get liquidated there just as much as you can get liquidated from the falling asset value of the thing that you go and borrow to buy. So Chapsky's explanation really might have worked on a jury, but sounds weird to people who are paying a lot of attention in finance and who are experts in finance, because this idea that a house in the Bahamas is going to secure the borrowing that you're doing from retail depositors in the FTX exchange is actually kind of insane, because you're not, actually monitoring that risk live. Basically, you're saying that you can do whatever. And this was another kind of, this is still a little bit of a mystery to me, but Sam actually testified under oath that any margin customer on FTX could do whatever they wanted with the money that they borrowed, take it off the exchange, use it for expenses, use it to buy real estate, do whatever. That might have been a policy at FTX, but it's a really weird policy if you're trying to advertise yourself as a safe exchange, which FTX did. Because if you have collateral that's off exchange, that's not being monitored, that's not live, then you have a problem, because you have way increased risk for even the people who actually are enrolled in that margin program, right? And, it happened. So that's all to say that this has been a really shambolic and comical effort continuously since the end of the trial, since the collapse of the exchange, really, by Sam Bankman-Fried to offer these kind of like, frankly, nonsensical explanations of what happened. Like, it didn't happen that way, and it's really, really obvious. So what you see here mostly is desperation, denial, repression. Um, all of it, again, explained in my book, Stealing the Future. Go out and grab it if you haven't, and check out Dark Markets. You've got the link right there. There's a deep dive into all of this in the most recent edition that went out on Wednesday. The psychic reality of the Silicon Valley mind is endlessly fascinating. The good news, though, and I guess this is the real summation, is that there is no parole in the federal system. Sam Bankman-Fried's appeal in November, that hearing went terribly. We have not gotten a decision, so that is still a very slim chance that his appeal somehow gets some kind of result. But probably we're going to get a no on that very soon. Well, fairly soon. Obviously, it's been more than 6 months since that hearing. They're not in any rush to give any kind of judgment at all, but we will hear soon on that. It's likely to be a no. And at that point, with no parole in the federal system, Sam Bankman-Fried has no opportunity to get out of prison in less than the more or less 25 years that he has been sentenced to. He's already served 3 or something, so it'll be 20 years, and then he'll get, maybe there's a couple years off for good behavior, but bottom line, thanks to the help of his parents, Sam Bankman-Fried will not see the outside of a jail cell until let's call it 2037, 2045, give or take. Does that sound about? No, that's give or take correct. Maybe it's more like 2042, but something like that. That's when Sam's getting out of jail, and not any sooner. It's kind of incredible. I saw him outside of a prison cell for one of the last times that anybody would, when I was at his sentencing, and his guilty verdict from the jury. Wow. Okay, I talked continuously for 35 minutes. Thanks everybody for joining. We have about 30 people here, which feels great to me. And obviously, check for the video once it goes up after this, and feel free to share it with anybody else who you think might be interested in the funny japes and scrapes of Sam Bankman-Fried and his deluded weirdo family. Thanks everybody for joining. I will make sure this doesn't keep drooping the next time I do one of these. So I'm going to end the video. Well, actually, sorry. Before I end the video, anybody have any questions? Anybody who's here want to type a question? I'll give you 30 seconds here, and if I don't see anything, I'll end the video. But if you've got a question, hit me. Hand is hovering here over the button. That's the thumb that's going to end it. So thanks everybody. Again, please share this. I would love, I always love more subscribers. So if you got friends who might be interested, please spread the word. We go ahead and end the video. Looks like you got no questions, but if you're a subscriber or if you're a paying supporter, there is a chat for supporters. So if you have questions that occur to you later, drop those and I'll be keeping an eye out. Thanks everybody. Take care. Have a great day.